Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not
We will
relevant.
bring the jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're doing commentary on the case. Dati mihi Anglican por his verbis Latinum.
Is that correct?
Oh, for Trump's sake. I didn't ask you to interrupt me.
Good morning, happy Friday morning. I had to check. Welcome to the Court of Public Opinion. I am the Recovery Addict. It's wonderful to have you all here today. I'm sorry I'm so late this morning. I had a 3D printer emergency. 3D printer emergency, and I fixed it. All right, let's turn the music down just a tiny bit. Fun day today. Let's see what's coming up. Is there a Corey Richards hearing today? She was on the morning news. What's the hearing on today? What delay is she trying to throw? All right. Welcome. Spent 10 minutes wrestling with my plant's grow light timer. Stupid thing. You know, some of that CBD stuff is hard to grow, I hear. Red pen. What kind of plant again? What kind of plant was it? You've got a grow timer in your plants. I'm not accusing you of anything. I'm just saying. Let's see. All right. Welcome. Another 3D printer excuse. Oh, house plants. I'm sorry. That's what I was thinking. I don't know why my mind went somewhere else. Did it start printing universe-ending nanomachines? No, it was close. Here's the thing. I have 2 brands of filament right now. I'm going to have like 6 by Monday. But one brand of filament is really good. It's just amazing. It prints. It's beautiful. It's a multicolor sort of metallic look. You've seen it. It's the blue-purple, sort of blackish purple thing. And the other, I've got like these multicolors. I've got orange and green and red, and I think it's just straight purple. And those ones, the filament just snaps, like just sitting in the air, feeding into the tube, the filament will just snap. And I don't know why it's snapping, so I don't know how to fix it from snapping. And it snapped and then got sucked up into the tube, and then I said, stop, because I don't want it to run out of filament. Well, apparently I should have let it run out of filament. So now it's stuck in the tube. It says, that's okay, I'll spit it back out. And now it's stuck between the two. And I had to, take the print head. They call it like a Boswell funnel. Obviously, Boswell invented it, but it's the 4-in-1 funnel. I had to take that off. Anyway, it's printing right now. It's working. It's printing a little toy that I hope to use to capture children's attention, because it's a weird look. It almost looks like a dice, a die, but it's sort of got weird shapes on it. But it rolls straight. So it has a name. I forget what it was. It's a weird looking object that rolls as if it were a ball, just straight. So, yeah, but it's not a ball. All right. Welcome. Chat is not on screen. I'll fix that. I don't know who was first in chat today. Let's see, Denisha. We need to recover out of crochet hooks. I hear you. I'm just. Let me do some digging. Let me do some digging on that. I don't know, like, the sizes and obviously it needs to be smooth so it doesn't snag the yarn. So let's see. I'd call them murder hooks, though. You got to have murder hooks. Greeners was first. Congratulations, Greeners. He wrote, let's do this. All right, Greeners, congratulations. You're first in chat. Thank you very much. And you guys don't think I was watching, says Red Pen. You were watching. Greeners first in chat. We're going to punish you. Internet is all yours, my friend. You've won once again, as you've won many times before. Congratulations. You get it for the whole weekend, I think. But what a beautiful day it is today. Hopefully you're getting good weather where you are. I have not been outside yet, which could change my view. But inside, it's a nice 70 degrees. which is beautiful, and it's not raining. And anytime it's not raining inside, I call it a good day. When you have an old house, if you know, you know. So everything is going well. We have a couple things to do before we jump to court, and we do have a little bit of court, believe it or not. I mean, there's like these guys.
He owns a business with his wife.
Yeah, we're going to go there, and so we'll do that. But 3D internet does not involve 3D printer maintenance. I can handle that part. I just can't be live while I'm in there fixing the printer. Those are knitting needles, not crochet hooks. Come on. Well, you can get creative with a crochet hook. I'm just saying, murder is possible. It's a little more gruesome, but let's see. Not to give anyone ideas. It's not that kind of stream. But let's do birthdays. Do we have any birthdays today? I can't gift memberships anymore this month. I lost a bunch of money on football. Josh, I am so sorry. It's almost like your wallet was willing your team to win. But the ref, who do you want to blame it on? The ref? Let's say the coach. The other coach got in the way. He just coached better or whatever. I'm so sorry, Josh. Let's see. We already sang to everyone for today, tomorrow, and Sunday. Do we re-sing to those people or just add my granddaughter, Coco, for today's song? She'll be 8 tomorrow. Yes, we're going to sing to Coco for sure. Is there anyone else who wants to be sung to today? Can you live stream 3D printing sometime? I've never seen it in action. Yes, I actually want to do that soon. I'm pretty sure I have a camera I can use. There's a camera that goes in this that I think I should be able to hook up and live stream. Of course, Mrs. R.A. wants... Now, she's gone, so I can do this. I know she's not watching. You guys, I'm going to bounce something off you before I bring up the conversation with my wife. And maybe this is a terrible idea. And if so, let me know. But I was going to make the argument as to why the 3D printer should stay, not get moved to, but stay on the kitchen counter where it has resided since Christmas morning. I'm just thinking that that since it already has been there, and we've lived quite nicely for the week, right? We've made it a week since Christmas. We can probably make it another week or 2 or 3 or even a month or a year. There's just we have made cookies, we've made food, we've had dinner, we've everything. It's not. You guys are not seeing it the way I'm seeing it here. I was with you on the tractor, but not on this. Sorry, says Greeners. The tractor parts are still in the kitchen cabinet. I kid you not. Nope, it's her domain. No. Mrs. Ori doesn't she likes, okay. It's never going to fly. Well, it's a good thing I bounced that off you. Now I have to find a place for the printer, apparently, which I could bring it in the office, but it's a little bit loud. Like, oh, you'd be able to. I'm going to have to print the enclosure to make it quiet, and maybe it can live in the corner. Honestly, it would be easier to show you court, show you the printer during court if it was in here, instead of running cables all through the house. Yeah, it would probably be easier to bring it online. Someone goes shopping for me. She's going shopping right now. Coco will be 8 years old. Be sure to mention that, boss. I sure will. Coco, 8 years old is a huge birthday. 3D printer belongs on the counter. Josh, thank you. I'm going to frame this one, printing this off and framing it. Yeah, it needs to move. I'm thinking today's the day. You can find space for it in your new studio apartment. You'll need if you keep I see where you're going, greeters. You have extra bedrooms. I don't right now. We've got, everything is full. Mine is on the dining room buffet. See? 3D printers, kitchens, they go together. Yeah, I'm with Josh on this, but clearly, I think Mrs. RA is with you. And when there's a discussion like this, she does win. You can put it on the porch where he will be sleeping if it stays on the counter. This is it. Rob at Law & Lumber has 2 3D printers in his office or studio. But does he have any in his kitchen? Okay, I think I've won long enough. We'll move it off the counter and give Mrs. R.A. her space back, which probably do that today. All right, let's sing Happy Birthday. I'm sorry I missed it. Let me go back and get the birthdays. We've got 2 of them to sing to. Coco, who is 8. A big 8. There we go. Coco and where was the other one? Little Stubby. Little Stubby, is it your birthday today? Little Stubby and okay, there we go. Everyone stand up, deep breath, shoulders back, project your voice to the bathroom, back of the not to the bathroom. You can project your voice to the bathroom if you want, but project your voice to the back of the room. Blend your voice with a neighbor. Warm up with me if you will. La 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 la. All right, we're gonna sing Happy Birthday to Little Stubby and Coco, who is 8. Happy birthday to you. Happy birthday to you. Happy birthday, Little Stubby and 8-year-old Coco. Happy birthday to you. We're going to sing to a dog, too. We're going to sing to Nitro. Nitro is a great name for a German Shepherd. I think it's probably one of the most common police names for German Shepherds as well. Like when it's a canine police dog. We'll sing to Nitro. Who's a good boy? Who's a good boy? Happy birthday to you. Happy birthday to you. Happy birthday, dear Nitro. Good boy. Happy birthday to you. There you go. We don't often sing to pets, but that time we did. It's an awesome name for a doggo. It's a great name for a German Shepherd. I think most German Shepherds should be named that. Coco, Little Stubby, and Nitro. So happy it's your birthday. I realize there are a million places you could be and a million people could have celebrated with, but you chose to be here with us. The privilege, pleasure, the honor, the joy is ours. Hopefully we can turn that joy back to you, make your day a little more specialer. Begin by helping yourself to free pancakes at Denny's, IHOP, Village Inn, Waffle House, McDonald's, Tammy Dunlop's House, Addie's Grill, Bob Evans, and Cracker Barrel. Nitro is also a great name for an American Gladiator. Go Capricorns. I left something out in the birthday thing. I'm not sure what it was. Coco, what are you? I have to ask Coco, what do you want for your birthday? What do you want for your birthday? Because I believe if you can tell us, Red Pen has to make it happen. Do you like ponies? Do you like a pony? Or a zebra? All these things are options for you. When you're 8, it's a special birthday. You pretty much get what you want. So, maybe a kitten or a goldfish? Coco wants to have a daytime sleepover. Her friends are coming over for popcorn and movies and doing nails, etc. Coco, that sounds like a great birthday. Happy 8th birthday. Little Stubby, you get what you want as well. Happy birthday. All right, drum solo, I think. There we go. She told me she wants a unicorn with a cheetah print on top. Hop to it! You can print all these things. You can 3D print them. They're not alive, unfortunately. But Greeners, thank you. I just about bust out laughing as I'm trying to sing the birthday song as he's suggesting moving the 3D printer to the bathroom for various reasons. And no, I'm not going to do that. She does love unicorns. Unicorns are hard to print because of the horn, believe it or not. 3D prints don't do well with objects that lean and are tall. Objects that lean and aren't supported. Let's put it that way. All right. Happy birthday. Let's go to court. Let's go to court because we have a little bit of court watching, not a bunch.
About what he's doing now for a living, and at the appropriate time, Judge, I would ask the court to set a bond that we'll ask for. But as to now, Judge, I would ask for a formal reading, after which I would ask the court to allow my client to stand mute.
Oh, we want a formal reading.
Plea of not guilty.
Where have we seen this guy before?
It is alleged that on January 2nd, 2026, in the city of Royal Oak at approximately 3:22 a.m., that the defendant violated the local ordinance 750.1671. This is being charged as a misdemeanor. It's disorderly. All other violations: tamper with a motor vehicle ordinance 278-18. There's only one count being charged.
Oh, great. Okay, I told him that would be the bonus. So,
Oh, great.
Okay,
Judge,
so it
he
was
does-
only one count.
Bonus.
Sir.
Bonus, just one
Thank
count.
you, Your Honor. Judge, we would then ask the court to stand my client mute, enter plead not guilty.
Okay, so we'll hail the, okay, defendant, did you say stands mute and a not
Yes.
guilty plea? Okay, thank you.
Thank you.
Look at that background. I bet this guy in
Assigned
the top right
counsel
has a 3D
requested.
printer.
Judge, he is unable to afford retained counsel, so yes, he is requesting assigned counsel.
Okay, counsel shall be assigned for this gentleman. Sir, is the Sterling Lakes Drive in Pontiac a good address for you, sir?
Judge, and I don't mean to cut my client off, but he did give me an updated address and phone number, both of which I sent to you and your
Okay,
clerk.
thanks. Did you get it already, Nancy? No. Okay, give me a second.
The Mr. Steinberg up there, I know he's got a 3D printer. As does possibly Mr. Pearson in the bottom center.
So
It's a witch bish. There's one name I have to say carefully. Welcome. Good to have you.
okay, I have a phone number on Keating and I'm sorry, an address on Keating and a phone number ending in 9794. He does have a sign. What do you have to say about bond and bond conditions?
Judge, he does work, however, at this time of year, he's in landscaping, and so snow removal is his business now.
Hang on.
It's been
Owen?
kind of up and down as it is in Michigan for our winters. That being said, financially, he does have money, but he's...
Let me mute him for a minute. Owen, top center, that's a trooper. Do we have an undercover officer making an appearance? Because that is one serious head of hair. It says Owen Denton, Trooper Lansky.
The court to consider a personal bond. He understands that he does have to appear going forward. I told him that if the court does allow a personal bond, there would be a money component added to the top of that, and that if he in fact failed to appear in the future, he could owe the court whatever amount of money this court deems necessary.
I'm just trying to see if he's...
Okay, the 3D print just printed. This is the tray it prints on. It's a metal spring steel tray, and it prints like this. So I printed this cool design, which is like two cones next to each other.
Okay, the court is setting
Dropped a piece.
a $7,500 personal bond with conditions as follows. Sir, you have to personally appear, whether that be in person or by Zoom, for any and all court events. In this case, if it has your name on it and this case number, which is the first case of our year, then you have to be here in court, whether by Zoom or in person. Do you understand that? You have to abide by any judgment, enter this case, surrender to serve any sentence imposed. Do not leave the state of Michigan without permission of the court. Do not commit any crime while released. You shall immediately notify the court in writing of any change of address from Keating or the phone number ending in 9794. You are not to use alcohol, marijuana, or any other illegal controlled substance. You shall check in with pretrial services one time per week. You'll get that phone number with the paperwork that they will give you upon your release. You must contact pretrial services by Tuesday, is that January 6th? January 6th, 2026 at 3:00 p.m. to set up the supervision. And we'll set this matter for a pretrial with Judge K. The notice to appear will be sent to the Detroit address, and you will have assigned counsel. Is there anything further requested or required of the court, Mr. Angot, on behalf of this gentleman?
I dropped to the cube.
Nothing
that
further
fits
on behalf of
inside
Mr. Greer. Thank
so
you.
that these
Okay.
can
So
stick
to
together.
recap, we held the arraignment, not guilty plea entered, assigned counsel. I have his address and his phone. The bond is 7,500 per cell. He has to be supervised by pretrial services one time per week. He has to call in, check in, and we'll set this matter for a pretrial. This concludes the arraignment. You're free to leave the Zoom. Thank you so much. Do we have anyone else for Mr. Angot? Okay, Mr. Angot, we have a Berkeley ready, but it's going to be later, so you may leave the Zoom as well. I need to call the traffic case right now, please.
Thank you.
Calling the case of SP 4605941. This is the state of Michigan versus Owen Neal Denton. Denton, unmute yourself. Trooper, good morning. Happy New Year. May I have your appearances, please? Start with the trooper. That means tell me your name, and then the defendant driver,
is the
tell me
trooper,
your
huh?
name.
Morning, Your Honor. Trooper Scott Lansky.
Okay, defendant driver, your name.
Owen Denton.
Okay,
Good
Owen's
morning,
not the
sir.
trooper.
You are appearing today on an informal hearing. You have three choices before the court. You can admit responsibility where it goes to me to assess fines and costs. You can admit responsibility with explanation. That means you give an explanation to the officer as to what caused you to meet him at the side of the road, how you treated him. You take responsibility for what you did. And if you're asking for some kind of consideration, that's where you ask the trooper for it. Or you deny responsibility. That's where you're saying to me and the trooper that you didn't do what the traffic ticket says you did. At that point, we have an informal hearing. I swear in the witnesses, I take testimony first from the trooper, then from you, then the trooper. The trooper has the burden of proof. If I find that he meets the burden of proof by just a preponderance of the evidence, then I have to find you responsible. If you go with an informal hearing, that's an all or nothing proposition. You will either leave the hearing with no ticket or with the ticket exactly as written. If you admit responsibility or admit responsibility with explanation, you do not have a right of an appeal. You may file a motion to try to set aside your part admission. No guarantee that it'll be granted, and you will have to post a bond. If you have an informal hearing, you do have a right of an appeal. If either side's unhappy, you may appeal and have a new hearing before the trial judge. By proceeding today with an informal hearing, you give up your right to be represented by an attorney. You're representing yourself to have this matter heard by a trial judge. I'm just a magistrate and or a jury. Having said all that, sir, what's your choice?
What was that second choice again?
Admit responsibility. That's where you're saying to the trooper, you did what the ticket says you did, but here's why, and you're asking for grace and consideration.
I'll do that, Your Honor.
Okay. What do you want the trooper to hear about you, please?
So 696, all that construction,
Yep.
everyone was slowing down at the same time. And I think someone in front of him slammed on their brakes, and he slammed on
So you're
his.
following too closely.
And I just didn't catch it right. And I'm also driving a manual, so I can't brake instantly, or it'll stall me out. But you could see how his truck went up and then slammed down on my crash bar. That's why we had to lift it up. If you remember that, officer.
Okay, so the rule of law is that you have to always keep enough distance between the car in front of you that no matter what happens, you have the ability to stop. Do you understand that now?
Yes, Your Honor.
Okay, Trooper, having heard all this, is there anything you would
Nope.
like the court to consider on behalf of this gentleman?
Yes, Your Honor. I'm fine with amending to impeding traffic regarding this case.
Okay, do you understand that, sir? He's doing you the greatest gift of all.
The greatest
Yes,
gift
sir.
of all. It's
Sounds like a
lowered.
Whitney Houston song, the greatest gift of all. And that's called, what was the motion impeding, right?
Yes, Your Honor.
Okay, so he's taking this from a moving violation and an accident that has a lot of points to a parking ticket that does not abstract with the Secretary of State. It's a parking ticket.
But it
Do you have
also
any
just
objection
generates
to
revenue
this
for the city.
amendment?
No, Your Honor.
Okay, did you want to thank the trooper for his kindness?
Yes, very.
Okay,
Thank you,
does he-
Officer Lansky.
Didn't
Thank
have
you,
to
Officer
do that.
Lansky.
All right, do you admit that you were impeding traffic on the date in question?
The greater gift is double parking.
Do you admit, sir, that?
Oh, yes, ma'am.
that you were
Yes, Your
impeding?
Honor.
Okay, the court finds you responsible for impeding. How much is impeding? I lost my list.
180.
Oops, here it is.
I think it's 180, Judge. 160, 180.
Okay, the fine is $175. How long do you need to pay?
So you
I can
split the
pay it
baby.
today.
Okay, the court gives you 7 days to pay. You can go online and pay and make sure it shows the updated charge when you pay.
Okay.
Or you can come in person. We're always happy to have you here. Or you can mail us a check or money order. Got it?
Would I just call the 44th district?
You can go online. We don't take payments over the phone, do we? No, we don't take payments over
Okay.
the phone. So you have to go online and go to the all paid button. Okay. All right. Thank you so much.
Thank you.
Take care, sir. Be safe on the road. Keep that
You too. Happy New
distance,
Year.
please. Okay. Thank you.
Adjust your
All right.
following
Thank you,
distance,
Trevor. I'm
please.
sorry for the long wait. Forgive me.
Good day.
Okay. Who do I have next?
We've got Vladimir Putin representing
I have
Chris
a
Coyle.
931 arraignment with Mr. Steinberg. Can you tell me the last? Do I have any PCCs ready?
Yes, Your Honor, both of them are.
Okay. I'm going to take the arraignment first. Could you tell me the last name again, please?
Lock.
Okay, 1 second.
Oh, good. It's our NASA friend.
It's Locks. I'm
I
sorry.
got
I
it.
said
Thank you. Calling the case of 2501967. This is
Is that
the
a
city
tie
of
he's
Royal
wearing?
Oak versus Michael Thomas Locks.
Is Michael wearing a
plural.
tie?
Ready,
like-
Your Honor.
Oh, there he is.
Ready.
Okay, thank you.
Ready, Your Honor. Michael L. Steinberg, P43481, on behalf of the defendant. The address is confirmed. The phone number is 248-9356.
We have to cut that
And
part
I
off.
need to catch up, please.
Every time I play Angry Birds, I'm going to think of your college video.
Okay,
Oh,
let's
good.
start, please, with the reading.
Read-
All right, Your Honor,
read
as to the
charges.
information, I've gone over to his satisfaction, waived the reading therein, asked his court to enter a plea not guilty. In addition, I've advised him of his constitutional rights as they apply today. He understands them. We'll waive that reading as well. We consent to being on Zoom.
Okay.
You consent? You consent? You consent by committing the crime.
Okay, and he lives on Wisner Street in Pontiac.
Yes, that's confirmed.
Okay, and I'll take the phone number now, please. Or did you chat it to me? No?
I said it to you over the,
Okay.
over, yeah,
Okay, I need it restated because I wasn't there when you. Go ahead.
okay. 248.
It's 867-5309.
Okay, is assigned counsel requested for this gentleman?
No, ma'am, he's intending to hire his own lawyer.
Okay,
He doesn't want the NASA lawyer. What is the hair
is
doing?
this an Operation
I just
Drive
noticed.
candidate?
Yes.
That's not a man bun. That's like a cross between a
Okay.
man bun and the Princess Leia.
What do you have to say about bond and bond
and a
conditions,
ponytail.
please?
It's like a
He was
three-way-
here at the appointed time. He is drive eligible. I just ask you to set conditions of no driving without a valid license.
Does this gentleman have a clearance fee that he can pay here? Okay, the bond is $2,500 personal bond. No monies due at this time with the following conditions. Sir, you have to personally appear, whether that be in person or by Zoom as
What's on
you're
the screen
appearing
behind
today,
him?
as ordered by the court. And for any and all court appearance, if you're in Operation Drive, there may be several hearings and you have to attend all of them until the case ends. You have to abide by any judgment, enter in this case, surrender to serve any sentence imposed. Do not commit any crime while released. That means do not drive without a valid license or permit. You shall immediately notify the court in writing of any change of address from Wisner Street or the phone number ending in 62. We'll set this matter for a pre-trial conference. You have Judge Meineke,
That hair is amazing.
and that will be, I think those are by Zoom, and notify your counsel of that hearing. Is there any clearance fee to be paid here? Okay, no? Okay, I'm not sure if there's a clearance fee, but no, that's okay. If, I'm just gonna write in here that if there is a clearance fee that needs to be paid, you may pay it now. I'm not sure if there is one, but they might help you with your license. Okay, I'm not sure if that's applicable, but I'm putting it in the ROA if that will assist you. Mr. Steinberg, is there anything further requested or required of the court on behalf of Mr. Locke?
No, ma'am. And my last one was at 9:46, so I'm going to sign off. If anybody comes, I'm a phone call away.
Okay, thank you so much. Thank you, Mr. Steinberg. Happy New Year. Thank you, Mr. Locke.
Regina Adams, thank you. 29 months
Okay.
makes you an OG.
Do we have someone for Mr.
No, we're going to bail for that minute. We've got another one. Josh just brought us. Congratulations, Regina. That is super exciting. 29 months. Yay, you're live. Thank you for the best 29 months. RA's Mods, thank you for being the best. Thank you. I need to find this one real quick that Josh just sent me before it goes away, because that's what things do that Josh sends me. They go away. Ask me how I feel about that. Okay. Okay, we need to go back just a bit. Let's see where we are. Let's see if this is it. Somebody's calling. Hold on one second. Hello? 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 Can you hear me? Hello? Hello? I tried.
Mr. Dropping are here, so we can take care of that one.
Okay.
Let's get everyone joined.
Let's see what this case is here.
Mr. Easterly, you don't need to speak to Mr. Dropping before we begin, do you?
I do not, Judge. Thank you. Happy New Year, by the way.
Happy New Year. All right, we'll get started. On the record in the state of Michigan versus Jameel Dropping, 2503377FY.
Ross Marchmino for the people.
Good morning, Your Honor. Robert Easterly for the defendant, Mr. Jameel Dropping. We are both appearing via Zoom and would waive any right to appear.
And you are Jameel Dropping, joining by video?
Yes, ma'am.
More
Thank
hair.
you. Today was to be the date for an adjourned preliminary exam, but Mr. Easterly and Mr. Marchmina, it's my understanding you have resolved the issue of today's hearing?
Yes, Your Honor. It's the people's understanding that both parties intend to unconditionally waive the preliminary examination. There is an offer to put on the record in which Mr. Dropping would plead guilty to count 1, counts 2 and 3 would be dismissed, and the people would consent to HIDA status.
Mr. Easterly.
That is my understanding as well, Your Honor.
Mr. Dropping, you have the right to have a preliminary exam. That's a hearing where the government must bring some evidence to demonstrate probable cause to believe these felonies occurred and probable cause to believe that you're the person who committed these felonies.
Happy birthday, Coco.
Do you understand the
Red Pen,
purpose
thank you
of
so
the
much.
hearing?
Yes, ma'am.
And your attorney is telling me you wish to waive the hearing, move on to circuit court. Is that your understanding of what we're doing today?
Yes, ma'am.
You waive your right to have the hearing. I'll send the case to circuit court for a plea or a trial or something else, but all of that would occur without any evidence or testimony being taken here in the district court. You understand that?
Yes, ma'am.
Your decision on this will be final. Once you waive your right to have this hearing, you can't change your mind and ask to hold this hearing in this case in the future. Even if you can't work out a deal you like, can't change your mind and come back to district court. Do you understand your decision is final?
Judge says no takebacks.
Did anyone make any promises or threats to you to get you to waive your hearing?
No.
Knowing what we
Jedi
talked about
Jen,
today, is that what you want to do?
2
Do you want to waive
years.
your hearing?
Yes, ma'am.
Okay.
OG.
And the preliminary exam has been knowingly and voluntarily waived. This case will be bound over to circuit court on the charges in the complaint. Circuit court arraignment is currently set for January 14. That date is automatically waived by administrative order of the circuit court unless Mr. Easterly decides he wants to arraign again. An arraignment is a reading of the charges. Usually it's waived. That means you don't have to go to court January 14 unless Mr. Easterly tells you to do so. Bond in this matter is set at $2,000 personal recognizance. Any reason we need to talk about bond again?
Not for the people.
Not for the defense, Judge.
Bond will be continued, so that means you continue following your bond conditions, Mr. Dropping. So keep reporting to pretrial services, showing up for court. Whenever you have a court date, Mr. Easterly will have to tell you about those. No firearms or dangerous weapons, no alcohol, marijuana, illegal drugs, and no assaultive behavior. Anything else we need to address for the record?
Nothing for people.
We have a case coming up here. We're
Not
just
for the
trying to
defense,
find.
Judge. Thank you.
Mr. Dropping, if you have any questions, make sure you contact your lawyer. That's what you have him for, okay?
Yes, ma'am.
And he'll bill you
Okay,
accordingly.
you're all set. You may hit leave.
Thank you.
Thank you.
What you doing? Happy New Year. 31 months. OG.
Ms. Schroeder, we did see your client, and she came in the courtroom for a little bit, and she's since stepped out. And then Ms. Robinson, we can bring your client up whenever you need him.
We've got another
I guess
baby-
I just don't know the
another
status
baby
of
prosecutor.
witnesses, so I'll let you guys sort that out.
This is Judge Stacia Buchanan.
33. So, yeah, 12 minutes.
Got a few minutes. We have a littering case coming up. Littering case
Just got my date stamp so I can
with video
grease this one up. Right back. Don't yell.
and witnesses.
Just know by now.
Josh, thank you for finding this little one.
Ross needs to be tortured.
I need to be tortured?
Nothing like the high crime and misdemeanor of littering. City ordinance
harassment.
violation. Hopefully it's a jury trial.
Gary.
Oh, Lord, they're loud.
Look at this. If you look at it from the side, it's like an oval. If you look at it from this side, it's a square. It's a cube, but then it turns. If you look at it from this side, it's like twisties. Not a lot of crime going. Yeah, it's a slow crime day. We're going to skip ahead just a teensy bit, try to get to the good stuff. Got a little bit of a break here. Long break. Oh, there we go. Let's wait. He comes in, pops a squat.
I like 10 retail products.
Let's catch the hot mics here.
I'm running on sand, you know, it's like a lot of extra effort.
We have an officer here.
Okay, cool. So we can run that one.
Just run it.
Okay, I guess we'll bring Gary
I
up.
want to wave up on no offers.
Yeah.
That's crazy.
Surprise.
Come on, Jerry.
No offers.
Make an offer because he keeps doing stuff.
It's like a minuscule amount of crack. Like, no misdemeanor.
Well, if he would leave Alta alone, he's got like 10 retail products.
That's the problem. Jerry's become too much of a frequent flyer on the retail part, fraud portion,
Well,
which may be a symptom of his.
The judge is like, wait, is this mic hot? Oh, it is. Okay, let me stop talking for a minute. Jerry, frequent flyer, might be making an appearance here. Let's skip forward a little bit till we get some audio. Are we ready? Are we ready? They talking smack about defendants? That's what I heard. Did I hear a minuscule amount of crack? I thought it was a minuscule amount of credit. Like time served credit is what I was thinking. Basically, the prosecutor made a very weak offer is what I'm gathering from that. And defense is like, it's not even worth our time to consider. Lindsay Ann, welcome. Good to have you here. Not invisible, just a lot of other chats that are popping up. So, what were those toys that came with a string that you could stand them on an end ages ago, not a top? That was a gyroscope, just Stephanie. A gyroscope. You wind a string around it and you pull really hard, and it has the middle part with its weighted that swivels, and the motion. It's the same thing, believe it or not. They have just a fancier version of that inside, like rockets and space shuttles and things like that. It's an amazing scientific principle that an object rotating in motion will resist a change in orientation. So now, do you want to do something fun? Here's a little science trick you can do yourself. Grab yourself a nice swivel chair like the one I'm sitting on, and get yourself a bike tire and put the feet grips on each side. So take the bike tire off the bike, and hold the bike tire so you're holding the handles. Does that make sense? You've got the bolt that goes through, and you tie the little feet grip handles on, so then you can hold at arm's length the tire doesn't hit you in the face. And then you get somebody with like a high-speed rotating device, like a sander, a belt sander, or if it's a spinning buffing device, to hold that against the bike tire while you're holding it in your hands. This is not safe, but I don't recommend it unless you know what you're doing. To get that bike tire like cranked up in speed, right? Like get that thing humming, and you're sitting there in your chair with your arms out. I have to cut to this so you can see. With your arms out, and the bike tire is spinning really, really fast, and then you try to turn the bike tire, and you'll start swiveling on the chair. Like feet up, you'll just start spinning, and then you turn the other way, and you'll spin the other way. Amazing science at work. I'm sure there's like a name for that, gyroscopic precession or something like that, but that was in a lifetime ago when I learned about that. It's physics. It's physics. To get a demonstration, I need a bike tire and a friend with one of those spinny things. Other than that, I'm good. The mood in the courtroom is quite jovial, as we can see. Prosecutor's having a good laugh. Judge is chiming in. Defense seems to, please don't encourage my, tell you, you're going to want to do it too, Cindy. Once you see him spinning, sitting on the chair and spinning, you'll be like, hey, sign me up. I will have done myself an injury before that point. Yep, physics in action. Most people should look up the word inertia on the road. Yes. An object in motion will remain in motion unless acted upon by an equal or greater force. Everything you just said went way over my head. Okay. Imagine your arms are the front forks of a bicycle. Okay? Pretend you're a bicycle. So you're holding the axle that the bike wheel spins on. Spin the wheel really fast while seated on a swivel chair, and then try to change the bike wheel from being vertical to horizontal. And if you do that, you'll start spinning on the swivel chair. And if you stop, it'll stop, and you spin the other way, you'll spin the other direction. That's it. Okay. Let's zip ahead a little bit until court starts. I wish I could hear this. A hot mic right now would be wonderful. It's just what we need. Let's see.
I suppose sequester.
Let's back up. Judge, we almost ready? Probably 30 seconds or so. To give a live demonstration, I will need a couple things. I will need a bicycle, a swivel chair, and like I said, a friend that has that tool. The bike tire, the faster it goes, the better the result. Also, the more dangerous it is. And it can really, you don't want bike tire to hit the face. So if you have a heavy, Judge, let us in. Hit the button, Judge. We're not on the record. Can you click the button? I know she turns it on. There it is. Push the button, click.
More than one witness.
Mr. Marchmina, are you calling more than one?
We only plan to call one witness today.
Okay. I suppose sequestration is ordered, but it's probably an order without much consequence today, as there is only one witness. Mr. Marchmina, your first witness.
People call Zachary Goodale.
We go straight to a witness, so we don't know if this is the right case. If it is, it's a littering case. Let's look for the gentleman in the nice gray vest with black shirt. If that's him, we're at the right case.
Evidence that it was originally had nothing, no evidence.
The defendant's more interested in what the lawyer's doing on the computer than his case. Mrs. R.A. came back from the store, got 8 gallons of milk and 2 flats of Deer Park water.
Before you're seated, I have to place you under oath, so if you can pause, raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth under penalty of perjury?
I do.
That guy's got full sleeves on both arms. He like steps over the barrier. He's so tall.
Okay, sir. Firstly, try to keep your voice up so I can hear you around this old COVID plexiglass.
Yes, ma'am.
And answer with words that my assistant here can type, like yes or no. If you say or nod your head, we can't spell it.
Yes,
You can
ma'am.
start with stating your first and last name and then spell both for us.
My first name is Zachary, Zachary. My last name is Goodale, Goodale.
Okay, thank you. Your questions for witness Goodale.
Officer Goodale, how are you employed?
I am employed as a patrol officer with the Lansing Police Department.
How often have you been so employed?
I have been employed for approximately 1 year now, swearing in December of 2024.
And as a road patrol officer, what does that entail?
So as a road patrol officer, it's my job to patrol the streets of Lansing, answer emergency calls for service, and just generally enforce laws and city ordinances within the city.
Now, were you working on July 15th, 2025?
Yes, I was working.
And around 4 p.m. that day, did you find yourself in the vicinity of Jones and Beeman?
Yes, I was on foot patrol in Jones and Beeman.
And that location, is it in Ingham County, City of Lansing?
Yes.
And when you were there, did you come in contact with did you come into contact with any citizens while you were there?
Yes, initially we were walking through Hunter Park. We had made contact with several citizens. We were notified of some information, and then we continued our foot patrol down the streets where we continued patrol.
Did you encounter someone who was littering?
Yes, we were on foot patrol and we watched an individual litter. He had discarded a piece of trash onto the streets, so we initiated a stop and identify the individual.
Now, this individual who you saw litter, is he in the courtroom right now?
Give this man a cape.
Could you please tell
He's
me
a
where he's
hero.
sitting and describe something he's wearing?
He's sitting next to the defense attorney, and he is wearing a inmate outfit.
Your Honor, could the record reflect the witness who identified the defendant?
Is
Any
it
objection to
in
identification?
custody for
No
littering?
objections for purposes of preliminary exam.
Thank you. The record will reflect identification.
And were you with another officer at this time?
Yes, I was with Officer Washington.
And the person who you stopped for littering, did he identify himself?
Yes, he identified himself as a Lansing police officer.
No, I'm sorry. The person you stopped, did he identify himself?
Yes, he stopped and identified himself as one Jerry Gary.
And did either you or your partner ask for permission to search his person?
Yes, my partner asked for permission to search his person.
Did he give consent to a search?
There's a lot of leading
He did.
here.
Did you conduct a search of his person?
I conducted a search of this person.
Did you locate anything of interest?
Yes. In his right pants cargo pocket, I located 2 white rocks that, through my training and my experience, I identified to be crack cocaine.
He had gravel on him.
Now, can you explain what a true narc test is?
A true narc test is a machine that we use. It scans the substances and it provides feedback, identifying the substance as either cocaine or methamphetamine based.
Did you conduct a true narc test on this these rocks that you found?
Yes, I did.
What was the result of this test?
The result was it tested positive for crack based.
And is that like cocaine?
I'm sorry, yes. Cocaine based, which is crack cocaine.
Yes, okay. Just wanted to clarify that. And was Mr. Gary taken into custody?
Yes.
Did he at any point say anything about what was found on him?
At one point, he made an utterance stating that the substance in his pocket was in fact crack cocaine.
Did he say anything about where he got the cocaine?
Did he say, "Don't
Did
take
you
my
recall?
crack"?
I do not recall where he got it.
Okay. No further questions.
Examination.
Defense, what you got?
All right, Officer Goodall.
Illegal search?
You were riding in a golf cart, correct? When you were in the area of Jones and Bement?
Yes.
Okay. And you were with another officer at this time?
Yes.
You followed Mr. Geary from Hunter Park, I believe?
Yes.
Okay. And you saw him, I guess, toss a bottle in the air and it landed on the ground, correct?
Yes.
At that point, you immediately got off of the golf cart and placed him in handcuffs, correct?
We did not immediately place him in handcuffs, so we detained him.
Well, so you told him to stop and drop his bag first, is that correct?
Correct.
And then when you approached him, you immediately handcuffed him.
I placed him in handcuffs just to detain him for the time being while we conducted an investigation.
Okay. So
Is she going to win
you
this
stop the golf cart, you tell him to stop, drop his bag, correct?
Correct.
And then you immediately placed him in handcuffs.
I would have to reread my report just to make sure I have an
Would looking at some body worn camera footage refresh your recollection?
Yes, ma'am.
Is there the record?
Michael Trowbridge, member for 25 months, OG on the jury. Thank you very
I don't
much,
use it
Michael.
very often, so I'm not really sure.
Defense going to body cam. This has got to be good. The court clerk has gloves on. I guess you never know where that HDMI cable's been.
I want to make sure that this is going to let you share, and I'm having an issue with them having done something to this.
Them having done something. Own your system, Judge.
Here we go. All participants can share. There we
Jam that plug in there.
They've updated the Zoom, so I don't know where anything is.
Oh, do I have to go in Zoom to do it?
No.
Oh, okay.
No, but my Zoom will pick it up.
Oh, your Zoom.
Yeah.
That means we get to
But
see.
I have it locked down due to, some things people did, and they updated Zoom and moved all my settings.
Oh, here we go. Let me get small on the corner so we don't. We're going to be up here in this corner. We're clearly inside.
All
a
right,
golf
so
cart
I know
right
this
now.
isn't your body worn camera footage, but it was the officer that was with you, correct? Officer Washington?
Yes, ma'am.
And he was sitting right next to you.
Yes, ma'am.
So it would show what you saw as well, correct?
Yes, ma'am.
And it would show a fair and accurate representation of what you saw on that day in July?
Yes, ma'am.
I am going to move to enter this in as defense exhibit, I guess 1, because I forgot to mark it.
Well, defense uses letters, but do you have something for her to tag?
I do. It's the flash drive that's on my computer, but I can give it to you when it's.
Okay, here we go. Full screen view. Just wait 30 seconds for the audio to come on.
All right, any objection to admission of A?
No objection.
A is admitted.
Can you play it a little smoother? Maybe get a computer.
So now there's no sound. I know no sound starts until about 30 seconds in.
Well, they're following him. You can see him.
Hey, come here. Yep, drop your bag, boss. Drop your bag. All right, you're good. Hands on your back. You litter.
I'm sorry. I'm sorry.
Okay, all right. Relax, relax.
I'm sorry, dude.
What's your name, brother? All right, I'll tell you this. I'm gonna ask one more time. You're gonna give it to me. We're gonna go to jail. Okay. Okay. All right. Ready? Do you have anything on you that?
No, I don't.
Okay.
So I'm going to stop it right here. But so you immediately get off of your golf cart. You tell him to stop and drop his bag, correct?
Yes, ma'am.
And then after telling him to stop and drop his bag, you immediately handcuff him.
Yes, ma'am.
You then ask him for his name. Is that correct?
Yes, ma'am.
And the reason for the stop at this point in time was because you saw him littering, correct?
Yes, ma'am.
Okay.
Where'd the defendant go?
After he was handcuffed, you then asked him for consent to search, correct?
Officer Washington asked him for consent.
I'm sorry, you're correct. Yes, Officer Washington asked him for consent to search, correct?
Yes, ma'am.
And he said yes.
Yes, ma'am.
Okay. And that's when the the search occurred and you allegedly found 2 small rocks in his back pocket. Is that correct?
In his right pants cargo pocket.
Would that be like back of pants, like side pocket?
So it would be the pocket that's on the lower thigh on his right leg.
Okay. I know that you stated earlier that a true narc test was done and completed on scene, but was the evidence submitted to the laboratory for further testing and analysis?
Yes.
Did you find anything else on Mr. Gary's person?
Just assorted personal items that I can remember.
Nothing that would constitute a crime, though?
Other than the crack cocaine, no.
I have nothing further.
Redirect.
No redirect, Your Honor.
Okay, there's our witness. Where are you going with this defense? What's your argument?
Additional witnesses.
People rest.
Ms. Robinson, are you going to offer any proofs today?
No, Your Honor.
Okay, we'll go to argument.
Let's hear the argument.
Your Honor, the people are requesting the court bind over on the sole felony count in the complaint, which is possession of cocaine. The evidence does speak for itself, so I won't belabor the point. He had cocaine in his pocket. He admitted that it was cocaine, that it was on him. To the extent that we're going to have issues regarding the stop and the detention, they did observe him litter, and that was plainly on the video. And I would note that littering on private property is a misdemeanor, contrary to 750.552. It's a 90-day misdemeanor. So they had the right to immediately jump out of the golf cart and cuff him. So that doesn't take away from the subsequent search. And I would note that the statute I cited is littering on private property. It did appear to be in a residential neighborhood, so that at minimum is probable cause to believe that he was littering on private property, which is beyond what is necessary for.
I didn't see littering in the video. Can you show me that? I probably wasn't looking at the right area of the video because I didn't know where he was going to appear. You know, I haven't seen the video.
My son made me scrambled eggs. The argument is they wouldn't have found my crack cocaine if they hadn't profiled me. He has been in jail for 6 months. It does seem strange that they went from, we saw you litter, hands behind your back. Hands behind your back. We're going to throw the cuffs on. Okay.
Looks like that's him up on the left.
Okay, we were watching the bike guy.
Looked like he was kind of tossing something with his left hand.
What? That's...
All right, see if I can adjust the playback.
Okay, we're watching on the left.
Hey, come here.
It's hard for me to tell from looking at this video. But you're saying the item he threw landed in someone's yard, not the street?
That's what it appeared to be.
There's no other body cam video or anything that gives better view of that item, so we don't know. I'm just curious. I'm not sure if the ordinance requires private property as the statute does, and he is charged under city ordinance, so.
I'm not a big fan of illicit drug use, but this seems like a bit of a... It seems a little bit much.
I think that the point generally that I was making is that they did observe a crime. He's not charged.
Well, that's why I wanted to make sure. Okay, the city ordinance says no person shall litter or deposit trash or refuse in any street, alley, park, or other public place, except in receptacles intended therefor, or except in or with city-approved trash bags or other city-approved method for a city refuse pickup. So it's charged under the ordinance, which is a little different than the state statute. And the reason I wondered is because you referenced the state statute saying private property, and it wasn't clear to me if he had violated the state statute, but it is clear, at least, that there is probable cause to believe he violated the city ordinance.
Yeah.
Okay, you may continue with your argument.
That's pretty much, I mean, I'm not saying that I agree with immediately jumping out of a golf cart and slapping handcuffs on a guy for dropping a piece of trash. But yeah, other than that, I would request fine over on count.
Okay, Ms. Robinson.
But the ends justify the means? Is that what you're saying?
Your Honor, I don't think that there is enough evidence in this case to show that he was, in fact, littering as to meet the statute or the ordinance requirement in this section. There's nothing to show that the specific piece of, whatever he was tossing, I guess, is a piece of trash to begin with. There was no testimony regarding what it was, if they collected it, that sort of thing, if it landed on private property or not. Further, they didn't even let him give him a chance to pick it up or do anything in regards to that. I've dropped things many times, and sometimes I forgot and had to walk back a block or two to pick things up. So there's nothing showing that there was a clear intent for Mr. Gary to litter. It was immediately, they were following him from this park, clearly waiting for him to do something in order to stop him. And as soon as they saw what they describe as littering, they did so in this case. So I would argue that I don't believe that there was probable cause to stop him based on the fact that I don't believe that there's probable cause for the littering.
No rebuttal, Your Honor. Just
no rebuttal?
Intending to request fine over.
Thank you. The burden of proof at preliminary exam is probable cause to believe the felony occurred, and probable cause to believe that this is the person who committed the felony. The court took testimony today from just one witness who identified our defendant, Mr. Jerry Gary, as the man he was encountering back on this date, July 15, I believe, of 2025, at a location in the city of Lansing, making venue appropriate in this court. I guess firstly, as to the issue of having probable cause to stop him regarding eyewitnessing an ordinance, it did ordinance violation, a misdemeanor. It did appear they at least had probable cause to believe Mr. Gary had committed a violation of the city ordinance prohibiting littering, as he was observed to be throwing an item, which is different from dropping an item, which is also offering him an opportunity to pick up the item is similar to saying a person who shoplifts should be given an opportunity to return the items, which isn't the law. Once the crime is complete, the crime is complete. Do I agree that they should have handcuffed him immediately over an ordinance violation of littering? Not necessarily, but no argument has been made that that was not lawful conduct once there's probable cause to believe that there was a misdemeanor. Therefore, as to the elements of possession of cocaine, first element is the defendant possessed a controlled substance, and in this case there's probable cause to believe he did possess cocaine. It was in his pocket. Second, the defendant knew that he possessed a controlled substance, and of course circumstantially he knew as it was in his pocket on his person, but secondly he admitted that he believed it was crack, so there's probable cause on that. And third, I think that's it for possession, simple possession.
This stop was going to happen no matter what. Even if he didn't litter, they would have got him for jaywalking.
We don't have to do that for this particular crime, so the court will bind over to circuit court the sole count in the complaint, which is possession of cocaine.
This was going to happen no matter what. They had a 3-man team on the golf cart following him, probably because an undercover observed him making a buy in the park. That's probably what happened.
Circuit Court arraignment will be set for January 14.
And by couching as a stop for littering.
Waived by administrative order of the Circuit Court. Means you don't have court January 14 unless Ms. Robinson tells you to go to court that day. It's a reading of the charge.
It's like, oh, look, we found crack cocaine. Lucky us. Good thing you're already in cuffs.
25,000, 10%. Shall we talk about bond?
Yes, Your Honor, I would like to address bond.
Go ahead.
Your Honor, we would ask the court to convert Mr. Gary's bond into a personal recognizance bond, or at least lower the bond amount from a 10% bond. Mr. Gary is indigent, and he cannot really afford much of anything of a type of bond in this case. He is staying at the shelter and has a place where he can return back to, he says. I have informed him about reporting to pretrial services, and he says he will abide by those conditions. He does have some services that he's a part of in the area, so we would ask that the court allow him a personal recognizance bond.
Mr. Martina?
I would just note for the record that Mr. Gary currently has 6 retail fraud cases in review, the most recent offense having been committed on December 18th. I think it's plainly obvious that if he's released on bond, he's going to continue to commit retail fraud. So I do think that the current bond is appropriate.
I think the optics are bad on this one. I'm not arguing the law is wrong, but the optics are bad. I don't like police doing something, pretending it's something else, right?
First,
oh, look,
I would note
we
for
pulled
the
you over
record
because we
that
couldn't see your rear view mirror.
This is a
Can you step out of the car so we can take a look and see if you've got anything illegal in
But I
here?
would also note that Mr. Gary has been in this court far too many times over the last couple of years.
Mr. Gary's who
Now
they're
there
talking
being a
about
substance offense. Of course, I wonder if Mr. Gary's shoplifting is all related to substance offenses. I'm going to tell you that when I go to our court system, Mr. Gary fills up to 3.5 pages of docket listings, each page being 17 entries. I don't even know what 17 times 3 plus a half is. Way too many.
Well, that would be 30 plus 21, 51.
51 is 17 times
51,
3 plus a half. So
plus
we're talking
half.
60 docket entries, Mr. Gary.
51
Stop getting in trouble.
plus 9, that's 60.
So bond is going to be reduced to 5,000,
Choose to
10%
calculate.
with all the same conditions, but I'm also going to order that defendant may be released to residential treatment. If you're in residential treatment, bond is 5,000 personal recognizance. Walk out of residential treatment, we'll go right back to 5,000, 10%. So if you would like to get out of jail and you can't afford your bond, you should consider going to treatment to address substance use in the hopes that maybe we don't have to keep coming across each other this way. If you'd like a transcript, counsel, please make sure you see Ms. Giesinger. Anything else for the record?
Nothing for people.
No, Your Honor, thank you.
Thank you.
I realize he's got a history with the system.
So,
I'll have a social from now. Thank you. Next steps about
Oops,
getting
careful.
rehab.
thank you.
Treatment.
Thank you.
Judge says treatment.
Well,
As he lose treatment.
Oh,
That's
yeah.
what you need. And she's right. He needs treatment. It won't stop on its own.
She wants my ruling on the littering so she can raise that emotion wash. Have at it. Have at it. It's great. At least you have something to raise, right? There's not always something.
Does anyone know if the CVRA allows crime victims to watch exams after they testified?
After?
After they testified, yeah.
I guess I'm not sure what you mean.
So obviously in a trial, even if there's sequestration,
Victims,
the victim
yeah.
can watch out. Is that also true in
I
Freeland?
think they're entitled to watch all stages of the proceedings under the Crime Victim Rights Act.
Even if there's sequestration?
I think so.
Okay.
I think victims can watch everything.
As can we.
I mean, I don't know if anyone's raised the issue of going back and. It's staged.
I have an advocate asking if the victim in Silva is allowed to watch, even though she already testified.
I mean, I think if she was here present in the courtroom, she could ask to sit here as a crime victim. So I think so.
I just noticed the little gnome on the shelf behind her computer. Do you see that? You see the little feet hanging off the shelf, a little elf on the shelf thing? I just noticed that. I couldn't tell what it was the whole time. All right. Not a fan particularly of how this went down, but I do acknowledge he needs help. Let's see if we can get caught up and see if what's happening here in this court now. Do they have anything else going on? Why are we muted? Remain muted. Now she's gone. Let's see if she comes back. Oh, we get sound back. Let's listen to this one, see what else is up. Was a legal stop. Yeah, I agree. It was legal. I just don't like the optics of it. The optics of, hey, we just saw you litter on someone's private property. First of all, I think that when it comes to littering on private property, the complaint must come from the private property owner. I know that's not a popular opinion because it means you have to sort of defend your property all the time, but I don't like the cops being able to basically say, hey, you're trespassing, you shouldn't be here, and then go to the private property owner and say, hey, do you want him here or not? No? Yeah, see, you're trespassing. That I hate that. I hate that part of it. But the profiling part where they immediately lock him up. Yeah. There is a case that's starting next week, which I don't think we can follow, and it's the Virginia au pair case. I think Court TV is the pool feed on that one. It has all the words. It has all the spice. It has, I'm trying to think of what this is. It's probably going to be on the same level of, I don't know, Mark Jensen as far as content-wise. Only instead of hand-drawn pictures in notebooks, it's websites and all. Sarah Grace Parker, which one's that? I have to look in that one.
Okay. I don't remember where we left off. Let's see.
I'm honestly, I believe that the content on that trial, it might give, YouTube might have problems with the content. So it would not surprise me if, I don't know, Court TV had to take it off YouTube and run it on their own cable channel or something. The girl who went alive to her parents was on TikTok talking about it. Yeah, I think we can follow that one. Give me some information about where that is. I think I have to dig in my notes. Lena H., member for 27 months. No better way to start the year. Lena, congratulations on 27 months. It blows my mind seeing that number. That is absolutely amazing.
Okay.
Well, I looked a little bit into that. I don't know why I stopped.
In State of Michigan versus Shafton Silva, 2402734 FY and 2403098 FY.
Ross Marchmina from the People.
Good morning, Your Honor. Jacob Starks, the floor, the Assistant Public Defender here on behalf of Mr. Silva. He's present in the courtroom. He's standing by.
And you're Shafton Silva.
Yes, ma'am.
Today is the date for continuation of our examinations. Where are we at? What's our status?
Your Honor, the people intend to complete the examination.
Okay, so do we have any preliminary matters before we begin taking additional testimony?
Nothing from the people.
Thank you, Your Honor. Just a request to continue the previous.
Oh, request to continue, and continue they do, which means they stop it right there. That was rather abrupt. All right. Judge Buchanan. Let's go to Judge Middleton, who's back.
Yes.
Might have to rewind on him as well.
The old probation clerk is coming back as a probation officer. Priscilla is going to be a probation officer.
I'm so excited for her.
Yes, so are we. We're happy to have her back. And we've hired a young woman named Evelyn Busio from Sturgis, who's going to be the probation clerk. So we're going to get fully populated down there. This is file number 252202FY, People versus Catherine Owens. That's you. And we've met. Miss Owens, you're in custody for a couple of things, but this one is a probation violation. It's the second one. I think we had a bond violation, and then immediately after you were on probation, it resulted in this arrest. So let me get to the correct file here. It started as a felony. It's 2202FY. It's a 25 case. You're placed on probation under domestic violence with a deferral on December 3rd. And then you got arrested a few days after that. Your probation officer, Daniel, was a bit frustrated with this because we hardly got off the dime. He's alleged that you violated your probation by violating another criminal law, failing to report, failing to pay fines and costs, failing to abstain from the use of drugs or alcohol, failed to participate in treatment, and failed to abstain from the use of assaultive or threatening behavior. According to this, you're going to plead to conditions 8 and 10, the use of alcohol or failing to test. Is that correct? As a violation of your probation?
I don't understand the failing to test part.
Well, it's just, all right. Do you acknowledge that you consumed alcohol?
I did, but at first I wasn't thinking, but then immediately after that I did submit to it.
All right. You're here with your lawyer, Casey Strong. She was your original attorney in this case and negotiated this plea agreement that put you on the probation. Alcohol is a big factor here, and you're spending much of the last 90 days in jail. And we're trying to get a handle on it. My intention is to continue your probation rather than just pull the pin and see if we can make some progress. But do you understand, you do have a right to have a hearing on this where it must be established, at least beyond a preponderance, that you violated the terms of your probation. Ms. Strong would be here to represent you. But you can also simply acknowledge that you consumed alcohol on that day. Do you understand?
I did.
And it resulted in a new charge, I think, also, but that's a separate matter, and you're represented by a different lawyer in that case. So what it says here is they're going to recommend time served, which would be 16 days. You're going to admit the violation, and I'm going to continue your probation. Is that your understanding?
Well, if I did time served, why do I still have to do probation?
Because I don't want you getting drunk and getting in a fight again. I want to get it.
It's time served for the violation. I'm going to stop.
Whoa.
The reason I was drinking is because I was stressed out.
Yeah,
Because
so
of all of this.
all right, and then you can tell me that. That's we're gonna have to play. What were you stressed out about?
Because I had a job to cover my court fines, and immediately after that hearing on the 3rd, the following day I was fired because I missed one day because I'd only been there for a few days at that point. So I lost my employment, and then my husband absolutely refused to help me pay for any of my fines. And that's why I hadn't done any of the anger management yet because I couldn't afford it. I was starting to look for work. That's what I was doing. And in that 2 weeks time, then after 2 weeks, I was so stressed out and fed up about it. Yes, I took a moment to myself and I got a beer. Yes, I did.
Say that again.
From December 3rd.
I heard that part,
Right.
but the last
And then I
sentence.
got fired. And then from December 3rd to the day that I was arrested, those 2 weeks, I didn't drink anything. I wasn't doing anything that I was not supposed to be doing. And I was so stressed out. My husband was just refusing to help me with it. After he and my son were the reason that I lost my job that I got to pay for my court fines, and my husband still was not going to help me with it. I was very stressed out. And then my son's girlfriend got involved.
Well, you said the last thing, and I didn't. You did something, and then you drank. What were you drinking?
The same thing I had the last time.
Which was Natty Lights.
Yeah.
Natty Lights.
All right, Daniel, what's your thought here?
Well, a vast majority about like not getting in treatment and stuff. I mean, realistically, she was only on here for 2 weeks. I do think that that she struggles with alcohol, and I do think that there's possibly some issues with some anger, and there might be mental health that I don't know about because it's only been 2 weeks. So I would like to keep her on probation and hopefully get some services in place that can help her make better decisions going forward.
Yeah, you've got an attorney pretrial on the new domestic violence charge in front of Judge Pattison on 17th of this no, what's that set for? 16th of January. All right, I'm going to follow the deal. I'm going to give you 16 days credit, 16 days. I set this for today because it's sometimes hard for your attorney to schedule cases in Centerville, and I knew she would be here today.
I'm always happy to come down here. Just not on a Monday.
Okay. 16 days credit, 16 days, 0 fine and cost. Probation is continued. Daniel, do you need to see her?
No, not right now.
Are you gonna
Just give me a call when she gets out.
I don't. All right. I don't know what the deal is in the other case. I don't have it in front of me.
I believe the bond in the other case was 5,000 cash surety, 10%.
Has it been posted?
Yeah, might as well pay that either.
All right.
So that means I'm going to be stuck in here till the 17th.
Well, we could discuss it further with Mr. Knopfinger, but the answer is maybe yes. I only have this case in front of me. All right. We'll take a look at that. Mr. Knopfinger, I don't think was here today, and I think his case has got adjourned that we're set for today. So as busy as it is, we're missing Miss Ives, we're missing Luke, and maybe somebody else. All right, Miss Owens, you're good to go. The deferral is still an open. What? Who we got left? Bring him in. Let's figure out what the heck is going on here.
Bring him in. Judge's ponytail is just hidden behind him from the profile view. If he turns his head, you can see it. He did not cut his hair off as a New Year's resolution or something.
Two five 9-7.
It seems like they could argue the inevitable discovery, but it seems like it's worth filing.
In honor of Stranger Things. I'm pretty sure that's not why he's doing it. A couple ponytails there in the courtroom.
All right, folks, stick with me. Let's see how we're gonna do. Sometimes we end up with no lunch.
No lunch? Don't think the commands are working.
Good morning, Mr. Cap.
Morning. On the right network. Everything's connected. I think they're working. Let's try it again. We'll turn it off and back on again. How about that? Okay, now try one person try one command.
Don't put a diplomatic plate on a hoop.
It's working. So it turned off and on again.
Have them send someone with more experience.
I'm getting some packages on Amazon. By the way, my wife's birthday is next week, and I'm curious, what do you think she would want? From what you know of her, what should I get her? It's hard because I just got her everything she wanted for Christmas. You to move the dang printer. Okay, so this is probably something. I'll do that. I think I'll do that today. Evangeline Light, I'm building some prototypes for an invention I've got. These are gears on a little wheel, bevel gears, and I'm trying to figure out the calculations of the size of gear I need to get the rotation speed right. Your wife wants another 3D printer. I was thinking the same thing, Lee. She's the only one that hasn't asked for something to be printed. Night away with the fancy hotel. Barnes & Noble gift certificate. First edition book. Ooh. Spa day.
Sorry, it took me a minute to track these down. Everybody have a seat, thank you. I had some confusion about these cases, and I was hopeful maybe today would help clear it
I'm
up.
having major deja vu right now.
But so far, there's still some confusion. Mr. Cap is charged in file number 251245 with malicious destruction. Oh, wait a minute.
What?
It's not him.
Malicious destruction. Maybe that's another
With
case.
driving with a suspended license, second offense from April 4th of 2025. open and tox in a motor vehicle from that same date. Another driving suspended, second offense from June of 2025. Those are all set for an attorney pretrial today with Attorney John Bush. Mr. Bush isn't here. We don't know where he is. My secretary's tried to contact him. Mr. Cap has
Paging
got
Mr.
a
Bush.
number of cases set for jury trial for February 11th. I thought we'd resolve some of this stuff. He has several cases set for jury trial in front of Judge Pattison. Altogether, there's about 10 of these.
Leonard, I love your profile pic. Dots are so yummy.
I took a plea. Well, no, he's bound over to circuit court on 24513 FY, pending, I think, a felony trial. And I thought I'd resolved some of these. Apparently not. At any rate, there was a plea offer, but Mr. Bush isn't here, and I don't know what the deal is. Mr. Cap, I'm hopeful we can resolve this stuff before you have a jury trial on February 11th. But I'm going to set these all for a pretrial conference in front of Judge Pattison.
Leonard, thank you very much. Happy New Year's to you as well. I think dinner at a fine restaurant would be good.
Set all cases for January 16th.
My second oldest wants to do this.
At
the
8:30.
Ninja one.
Did you had a trial date on your circuit court case? Is that this month?
As far as I know, Your Honor, we came to a conclusion on an impaired, and I was trying to be screened for
sobriety
court, as well as I had 2 driving on suspendeds with the city and 2 with with 2 with you and 2 with him.
Yes, and I thought, frankly, I thought everything was taken care of, but these things were still hanging out there.
Yeah,
maybe Mr. Bush thinks so too, but no one's here to resolve the question.
I'm a big fan of.
You're set for sentencing in front of me.
The 9th, I think, of February.
Yes. I thought we had resolved all of this stuff, but maybe there were some things that weren't on my radar.
I was under the assumption it was allowing another to drive a motor vehicle, possibly.
It was. That's what the plea offer is.
And then it was getting all bunched up, but I'm not sure exactly what.
Well, there was so much stuff, and you and I had a discussion of this. Screening and sentencing is set for January 20th, 6. All right, let me look at that case. Two 52477.
Well, the judge is looking it up. How's 2026 treated you so far? Now that we're 24 hours into it, y'all doing okay? If RA makes me mod for a day, Josh will give 10 memberships. You spelled 100 wrong, Greeners. You spelled 100 wrong, and Josh lost all his money on the football game. No memberships for a while.
So much stuff in here.
Oh, Girly Jones, I'm sorry. I'm so sorry. Starting to plan my 30th birthday. It's going to be fun.
Plea offer, impaired driving second and attempted R&O. owes $3,000 and unpaid fines and costs. Has jury trial set for January 2026 in circuit court. I don't think these things were addressed. They're all left hanging out. So I'm going to reset them. They may end up being dismissed in the light of everything else that's going on, but I'm going to reset these for January 16th at 8:30 in front of Judge Pattison, who's got all those other cases which are set for jury trial. And I don't know what the status of your circuit court case is. Now, here's Rhonda sending me an email. She must be watching the channel.
What's up, Rhonda?
Status of my circuit court is.
We resolved a felony DUI case. He's scheduled for sentencing 1st of February. You left open the option for sobriety court, but not very hopeful. All right. All I don't know is these cases are still out there. Your lawyer's not here. We're going to reset them for January 16th in front of Judge Pattison. Maybe you can resolve all these traffic cases that are still pending.
Your Honor.
In the meantime, you can go back to jail and get lunch. All right, good luck.
All
right, thank you.
Your Honor, how about
all right,
a show cause for the lawyer?
We're still plugging away here. Mr. Truckey's got a couple of clinkers. Let's do Cole Kindig. This is file number 252335OD. Are you Cole Michael Kindig?
Yes, sir.
Mr. Kindig, you were charged with operating while intoxicated.
Yes.
Prosecutors agreed to reduce this to a lesser charge of impaired driving. This is a White Pigeon ordinance case. Mr. Coaches from the village of White Pigeon has offered to reduce this to impaired. You've been waiting patiently all morning, as everybody has, to understand that impaired driving is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $300.
Yes, sir.
Carries 4 points, but it would allow you to keep a restricted driver's license, drive back and forth and in the course of employment and other limited purposes.
Yes, sir.
Ian,
all right, let's talk about your case.
Pigeon business.
Well, good morning, Rhonda, where we are. Got to get out of Mr. Cap's cases.
Nice watch, Judge.
Well, this one isn't in the queue either. So that's the second time that's happened.
Auto dismissal?
Oh, there it is.
Oh, bummer.
Still only one, Miss Alexander. All right, let's talk about your ticket, Mr. Kindig. You got it at 1:27 in the morning on November 16th.
Yes.
At Chicago Road and Kalamazoo Street in White Pigeon. That's just down the road from the Tomahawk. Is that where you were?
My buddy just bought a brand new house in Elkhart. I went down there
and we had a few drinks. I had a couple beers and a couple shots when I first got there. And then I waited a while to leave, and I thought I was okay. Guess I wasn't.
Well, you didn't wait quite long enough. Your blood alcohol is 0.105. You accept that?
105.
That's what the ticket says.
I think on the PBT, Your Honor, they did the breath test and it came back as a 0.096, 0.094.
Oh, all right, 0.096. If you slept a little more, you might have got under the legal limit, but this was still over the limit. All right, what do you do, sir?
So during the day, I'm a union pipe fitter, and then after work, I go out and plow snow.
You've been busy lately.
Yeah, long days.
You live in Portage?
I live in Kalamazoo.
All right, I'll accept your plea. Unless, where did I put you, Mr. George, for sentences? I think I filled up that date.
Is that the 9th, Your Honor?
9th, I think is full. Let's take a look. Yeah, there's 3 on there already, plus one of them is Mr. Cap. Are you available on the 16th?
Of February?
Yes.
Yes.
Are you, Mr. George?
Is the court
Wait,
open?
is that a Tuesday?
Is the President's Day? Is the
Oh,
court
it
open?
is. That's why it's blank. Usually I'm gone then, but
We've got the whole day open.
I'll be
Judge.
here. Yeah, that's President's Day. Boy.
Brooke says, member for 29 months. I'm sure no one noticed, but I haven't been watching the last 2 weeks. I missed Festivus, but it was a blast. Glad to be back. Brooke says, welcome. Good to have you back.
Go this far.
29 months. Oh, gee.
I guess I'll cram it into the 9th. Let me see. I don't want to jam up the probation department. Fowler is a drinking driving. Alvarez is a drinking driving with a translator, and Cap is a drinking driving. So that takes all 3 probation officers. Wow, we're going to go to March 2nd. Does that work for you?
Yeah, that works.
I'm gone one Monday in February, and the other is President's Day.
Yes, sir, that works.
I guess an impaired driving conviction would still allow you to plow snow. It's in the course of employment.
If your boss is okay with you having DUIs and being a snowplow driver, that is.
All right, Mr. Cole, you take this off the counter. Give your new address also.
Thank you so much.
I'll see you in March.
You have a good day.
All right,
Last one I have is Miss Gonzalez, Your Honor.
let's do that one.
Hello, ma'am. Welcome. trying to do like physics and geometry math in my head. And it's not working very well. It doesn't
Are you
work when I do it
Giselle
on
Ann
paper either.
Gonzalez?
Yeah.
You're here on a charge of operating with a high blood alcohol level, which is a ordinance, they can't do under ordinance, so it charges operating while intoxicated. Prosecutors agreed to reduce it to impaired driving. That's in file number 252427. That allegedly occurred on November 23rd of 2025. On the same day, they charge you with minor possessing alcohol and open intox in a motor vehicle. Then there's another one, 252430, open intox and MIP. And there's more, yeah, but in this case, the charge is going to be impaired driving and allowing another to violate the motor vehicle code.
Yes, sir. And I can give some clarity. The prosecutor did file a formal complaint that charges high BAC, open intox, and MIP. That would leave a driving suspended under ordinance. So it's my understanding that Ms. Stoll was offering an impaired for the county portion. I talked to Ms. Genschmidt this morning, and she would ask for an allowing for the driving suspended charge.
Wow, everything just got dropped.
All right. Ms. Gonzalez, you've been here all morning. Operating while intoxicated, suspend your license. This is a lesser included charge known as impaired driving. Impaired driving is a misdemeanor punishable by up to 93 days in jail, a fine of up to $300. But allow you to keep a suspended driver's license, restricted driver's license.
Yes, yes, Wendy. Didn't hear yet what her blood alcohol content.
You understand?
Yeah.
All right. Did anybody threaten you to get you to plead to this charge
No,
or promise you anything?
no.
And you signed the advice of rights,
Yeah.
acknowledging that you're waiving those rights by entering this plea. Is that correct?
Yeah.
Let's look at this ticket.
Succulent shaped nesting dolls, like a cactus, nesting cactuses.
All right, you got arrested on November 23rd in the village of White Pigeon for having a high blood alcohol content. They filed a formal complaint, but I can't tell what the alcohol level was. They also charge you with driving with a suspended license. Let's take care of that one first. They're going to reduce that to a charge known as allowing another to violate the motor vehicle code. That carries no points, doesn't get abstracted to your driving record, won't affect your ability to keep or maintain your license. Do you understand?
Yes.
All right, that day on November 23rd, was your license suspended?
I don't know. I didn't know until I had gotten arrested. They had told me that my permit was expired, not expired, but was suspended and everything. So I wasn't aware of it until they had told me.
All right. That charge is also a misdemeanor. It's punishable by up to 90 days in jail and a fine of up to $100. Doesn't carry any points, and it doesn't go on your driving record. You understand?
Yes.
I just want to know what her BAC was, and then we can jump to another court, Judge, if you can hurry. I think he skipped that part.
All right.
He's distracted, as am I.
I think you spent 2 days in jail, 2 days jail credit, 2 days. 0 fine, $125. I'm gonna make that due by
30 days.
February 2nd, 2026.
Great idea, Judge. We think alike. All right, we're going to jump for a minute. We've got this other court we're going to try to find really quickly where apparently the judge is going off on somebody. Let's see. Yeah, give me a second here. It's this one. Let's back up a bit. Okay, Josh, just need to make sure that's our guy. That's him. Bing, bing, bing. Okay, let's try this.
Resolution of this matter, Mr. Dick?
We do, Your Honor. Mr. Behrens will be entering a plea today to an added count.
Back up a tiny
bit. On February 12th.
Yeah, have a good day.
You too. Next matter is the state of Michigan versus Stephen Behrens, file 25-43915-SD. Is Mr. Behrens with us?
Mr. Behrens, turn on your Zoom.
Unmute and start his video.
James Dick on behalf of Mr. Behrens. Mr. Behrens just turned on his camera, Your Honor.
All right, I do see Mr. Behrens now. Do we have a resolution of this matter, Mr. Dick?
We do, Your Honor. Mr. Behrens will be entering a plea today to an added count 2 of operating while visibly impaired in exchange for a dismissal of the original count 1.
That's accurate, Judge.
Thank you, Mr.
Behrens
Portier.
under his house right now.
Mr. Behrens, is that what you want to do today?
Yes, Your Honor.
My understanding of the agreement is that the more serious operating while intoxicated charge would be dismissed, and you would be pleading to the less serious drinking and driving related offense called operating while visibly impaired. Is that your understanding of the agreement?
Yes, sir.
If you want to take that deal, you'd be giving up your right to have a trial and all of the things that would happen at a trial. Do you understand that?
Yes, Your Honor.
Let me tell you what those things are so you can make an informed decision. At a trial, you'd have the right to have a trial in front of a judge or a jury. You'd have the right to be represented by your attorney. You'd have the right to see, hear, and question the witnesses against you. You'd have the right to produce your own witnesses and evidence and get an order from the court called a subpoena to require those witnesses to appear and testify. At a trial, you could also testify, or you could remain silent and not have that silence used against you. At trial, you'd be presumed innocent until proven guilty beyond a reasonable doubt, and that burden of proof would remain with the prosecutor at all times. Finally, at a trial, you have the right to automatically appeal any error at that trial. However, if you enter a plea, you'd be limited to asking the court for permission to appeal, and it might not be granted. Do you understand all of those rights?
Yes, sir.
Do you have any questions about any of those rights?
I do not.
Is Jordan in the same place?
Knowing all of that, do you still wish to enter
Both
your
have the
plea
same
today?
roof.
I do.
Laura Michelle's.
All right, I'm going to ask you to raise your right hand so I can swear you in.
Almost an OG.
You swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, go ahead and put your hand down, sir. Other than this plea agreement, has anybody promised you anything in order to get you to plead today?
No, they have not.
Has anybody threatened you in any way to get you to plead today?
No, sir.
Are you doing this of your own free choice and free will?
I am.
Yeah, you said all the right things so
All
far.
right. The amended charge against you of operating while visibly impaired would read as follows. It would say that on or about June the 29th of 2025, in Charlton Township of Otsego County that you did operate a vehicle upon a highway, that is M32, while you were visibly impaired from the consumption of alcohol. Is that what happened?
It was opiates, sir, but yes, that
All
is
right.
what happened.
Thank you. Visibly impaired from the controlled substance then.
Yes, sir.
And so why don't you tell me what vehicle you were operating at that time?
It was a white 2015 Jeep Cherokee.
And prior to driving, had you taken in any controlled substances?
Yes, sir.
What was that?
It was a pressed pill, but I'm guessing it was probably fentanyl. It wasn't like a pharmaceutical one. It was like a homemade thing, I think.
You
All
just
right.
took.
You're satisfied that that was an illegal controlled substance that you were not supposed to be consuming. Is that correct?
Yes, sir. Absolutely, yes.
All right. And did that consumption of that pill have the effect of making you visibly impaired in your ability to drive?
Yes, sir.
All right. Do either counsel have any additional factual basis questions?
No, Your Honor.
No, Your Honor.
Okay, so
And you've
far so
complied
good.
with the court rule.
Thank you. Any other promises, threats, or inducements that not stated on the record?
No, Your Honor.
No, Your Honor.
All right. I do find that Mr. Behrens has given me a proper factual basis. He's admitted to consuming a controlled substance prior to operating a vehicle on a highway on M32, and that consumption led to him operating while visibly impaired in his ability to drive. He's also given me that statement knowingly, intelligently, and voluntarily based on his answers to my questions, so I will accept his plea.
Judge is going to go on a rant here. That's what we're watching for on this case. Yeah.
Mr. Dick, do we need to adjourn for substance abuse assessment?
No, Your Honor. The substance abuse assessment was sent to the court right after the last hearing.
Oh, let me see if I can find it.
It would have been December 11th. I believe. Sorry, maybe.
So Mr. Behrens and Mr. Jose are in the same place. Both their ceilings are unfinished studs, rafters.
The 18th, I
plywood.
apologize.
Out in their man caves.
I do not see it within the court file, Mr. Dick. You have it with you now that you could send to me via email or send to Mr. Horgan?
Judge, I just sent it to Mr. Horgan.
Thank you.
There should be 2 attachments to that email.
Yes, Your Honor, and I apologize. I sent it directly to Mr. Fortier and did not copy Brent on this one.
It's all right.
Here at the court.
Stuff happens.
Stuff happens.
I think I hear it coming in now, so if you give me just a minute to review it, then we can proceed with sentencing.
Stephen Behrens, hands in pockets, giving us the full profile view, or the full, not the full view, but the low angle is what we're getting here. Happy New Year, Skybell. Thank you very much. This is a Josh special. If you don't like it, it's Josh's fault, not my own. One of the benefits of having mods who make great suggestions. We are limited on what we can watch today. Everyone's going to be back at work on Monday. The court options will just blossom like a rose on Monday. We'll have all sorts of courts that will be up and about, handling the cases from Christmas. I guess we're still getting some Thanksgiving family fights cases in right now. The arraignments should be done unless you're in Georgia, and then you're going to be arraigned sometime next year. And by that I mean 2027 if you're arrested this year, at least in Fulton County. Take your time, Judge. All right. Now what? Mr. Barron's looks like he has other places to be. Yep, here he goes. He gone. I think he's at work. Holly B. You want the naughty trial? It's in Virginia. It's the au pair trial. Au pair. I think it starts on the 12th. So you got another week or so. A week from Monday-ish. Roughly. Phil, TYO Toys might be there for you.
When you go to your appointment, quick bro, you can get some from your counselor.
Steven's like, sorry, my coworkers are really loud. Is it in a closet? Or worse, is that the bathroom? Right, Allie B. I just want to see what it's about. It's murder, an affair. Want to watch a new trial? We'll get new trials, but we have to wait for them to start. So. Why can't we watch the au pair? I believe it may cause major problems for the channel, like YouTube's terms of service type challenges. Some of the evidence is extremely explicit. So unless I decide to go just nonprofit, which I can't afford to do, it's bad. Monday's the TikTok Georgia case. That's going to be awesome. Yeah, we'll have trials. We'll have trials. I'm not sure where we're going to go exactly. There's a lot of stuff happening at the same time, and we just want to wait. I don't like announcing something until it actually is going to go forward. That's the thing. Everyone's like, "What's the next case? What's the next case?" You guys know that that court, the day of trial, things can change. So, Phil, you might be in the photography pool. That's going to be awesome. Maybe you can share in the most PG, not PG-13, but most PG way possible. What are the details on the au pair trial? I just think it's going to be quite spicy. We can't watch the TikTok trial. It's too early in the year to pick on Georgia, says Josh. I can fast forward through this, but as soon as I pick it up and start doing it, he's going to start talking. Let's zip forward. Okay, here he goes.
Nope,
went too
both
far. Phil, do you need anything from me to facilitate that?
All right, I have received the ASM Continuum both the criteria decision engine form and the narrative report. I've reviewed both of those in regard to Mr. Behrens. The indication is that he is receiving and needs to receive high level of treatment for his opioid addiction, heroin and meth. Appears to me that Mr. Behrens, are you currently in a treatment program?
It's the sober living facility run. It's owned by Bear River. It's just in like a transitional housing.
All right. So I've had a chance to review that.
Sorry.
It's all right. Mr. Dick, do you wish to proceed directly to sentencing now?
Yes, Your Honor. And just for your knowledge, he is in a treatment program. He is in intensive outpatient 4 days a week, 3 days via Zoom, 1 in person with Bear River still.
All right, thank you.
Yes.
Mr. Behrens, what I'm going to do then is I'm going to hear from both of the attorneys, what's called allocution, that is their thoughts on what the sentence should be. Then after you've had an opportunity to hear both of them, I'm going to give you an opportunity to address me as well, and then I'll decide what to do with your sentence. So Mr. Fortier, your thoughts on sentencing?
So Judge, first thing I want to say is I'm glad that Mr. Behrens is alive and here with us. He had 4.6 nanograms per milliliter of fentanyl in his blood. Fentanyl, as we all know, is one of the most deadliest drugs available on the streets right now. It's a huge problem in the United States. So it's fortunate that, you know, he's with us today. It's also incredibly fortunate that no one was injured as he was, you know, found passed out, unconscious behind the wheel of a car that was still in drive.
Oh my goodness.
He was very forthcoming with the officers. I do recall that he had done some inpatient treatment as part of the pendency of this case. So I truly hope that he's getting the help he needs. This is his first driving under the influence related offense, although it's not his first substance abuse related offense. He does have a possession of cocaine or heroin back from 2022 and another one from back in 2011. So I think it's obviously apparent from the evaluation and that there's an issue. Glad that he's addressing it. I think that part of the court sentence should be him continuing on with that treatment, as the opioid use disorder is obviously something that's very significant and needs a lot of stabilization.
It concerns me that he didn't think he was in treatment.
That he's getting that help. I would just ask that he continue on with that. I would ask that the court order the traditional classes that we do with these kinds of cases, the alcohol highway safety class and the victims impact panel. I don't see that I received a reimbursement request, but we can check that before the court finishes its sentencing. But other than that, I think maybe, you know, some community service and/or work camp as the court sees appropriate would also be warranted.
All right, Mr. Dick, your allocution, please.
Yes, Your Honor. So, Mr. Behrens, he when he was picked up on this charge, subsequently, not initially when he was first stopped and arrested, he did realize he needed to do something to really get his life together. With this, it was kind of, unfortunately, at this point, it took this long, but it was a wake-up call for him. He had previously completed the sobriety court here back in April of 24. He did a full 2 years in the program. He did, upon release from being in custody for this matter, he did go to Bear River and enroll in their inpatient program. He did graduate after 30 days, and he has been in sober living in Charlevoix since. He was in the Bear River program from October 29th through December 2nd. On December 2nd, he moved to the sober living, and he's been doing well at sober living. He did find some full-time employment at an Applebee's, which unfortunately is about 25 minutes away. So he does have a little bit of a drive to get there. As I mentioned a few minutes ago, he is currently in intensive outpatient therapy. He does 3 days via Zoom, 1 day in person, like face-to-face. He's doing well in general, his health, his mental state. The people in the sober living home, they are good and helpful to him. They're supportive of each other. He believes that this is the kind of ongoing accountability and structure that he needs to remain on the right path. That being said, Your Honor, as is reflected in the assessment or ASCM report, he does have a long history of substance abuse issues, and he has struggled with it. At this time, Your Honor, we are asking that the court just consider placing Mr. Behrens on probation and ensuring that he has the continued tools and support that he needs to maintain his sobriety.
Thank you, Mr. Dick. Mr. Behrens, this is your opportunity to address me. Is there anything that you want to say?
Say the right things.
Yeah, I wrote something, if it's okay if I read it.
Yep.
Your Honor, I want to apologize for my actions. I've worked really hard to get my life back on track and to get off probation. My adult life has been ruled by drugs. Every time I have gotten in trouble has been because of my drug use. I have done everything I can to get my life together. I'm not trying to make excuses for what I've done, but I was going through a bad breakup, and when that happened, I turned to what I knew for comfort. But I'm grateful that I got this OWI, or impaired, because I know it could have been something worse. I could have easily killed someone that day, and that really scares me, Your Honor. I have went to treatment. I'm in sober living. I'm doing intensive outpatient, and I go to substance abuse counseling. I also go to AA and NA meetings almost every day. I know I want to be sober, and I'm doing what I believe I have to maintain long-term sobriety. This charge was a wake-up call to remind me that I will forever be a man in recovery. Before this happened, sir, I was sober for 3 years. You know, I did everything I could to remain sober. I've always been against drinking and driving, or, you know, and I know I easily could have killed someone that night. So I'm sorry.
Thank you. I appreciate the comments, Mr. Behrens. Mr. Behrens, you present me with a conundrum. On one hand, I have an individual who has a criminal history, including drugs and alcohol, or drugs anyway, that dates back a number of years and has some very serious convictions. Back in 2011, you've got a controlled substance felony offense with a habitual offender attached to it. You've got a number of breaking and entering, attempted home invasion, uttering and publishing, additional home invasion. Then you also have, as late as 2022, another substance abuse narcotic felony offense In addition to that, another uttering and publishing and larceny a building offense, and then breaking and entering. So you are on a man on a mission to go to prison. And then you add to that the substance abuse issues and the fact that you've been to treatment and you've been through sobriety court. And here we are still dealing with this issue.
Yes, sir.
So on one hand, I should just put you in jail and leave you there, because that's the only way to make sure that you're not going to hurt yourself or somebody else out there.
Absolutely.
On the other hand, I'm the drug court, sobriety court judge. So I see what this insidious disease does to people. It gets in and it starts small and it wraps its tentacles around you and it doesn't let go very easily. You are doing right now what you're supposed to be doing, which is go to treatment, work really hard at it. And it appears that from 2022 to now, you've kept your nose clean, relatively speaking, until the last few months. Yes. But you know better. You know what your triggers are. You've been through the treatment programs. You know how to deal with those issues, and you still didn't. That report that I read, the substance abuse assessment, said that you were, in the last 30 days, you'd used 27 of the last 30. 3 days before you had the assessment, you'd used. And you've been to treatment 7 different times.
Yes, sir.
Don't get lost in the details here. You may disagree with something I said, but just bear with me. All right?
Absolutely.
So,
yes.
So I get it. Substance abuse is a difficult thing to kick. But we've thrown at you everything that we know how to do to help you kick it, which just goes to show how difficult it is. But it also shows that the only person that can do it is you.
Yes, sir.
So here's where we're at. This is a first offense as far as the alcohol, as far as the drinking or the drugging and driving portion of the statute is concerned. This is obviously not your first conviction for anything, but it is a first offense under the drugged or drunk driving statute. So I'm not going to treat you as a habitual offender because you're not under this statute. But you are a habitual offender as far as substance abuse goes.
Yes, sir.
So I'm going to leave you in treatment, because when I first looked at your substance abuse assessment and I looked at your criminal history, I thought, how much time have I got and how long can I keep him in there?
I get it.
And the answer to that is not long enough. So just putting you in jail, even though it will protect the public, isn't the answer. But I need you to know that if you so much as hiccup the wrong way, that's where you're going to be. I don't care what the circumstances are. I don't care why you may want to do it. I don't care about anything else. At this point, it's not just about you. It's about protecting this community.
I completely agree.
So if you need some assistance, then get it. Do it. Use it. If you need to go to NA meetings, if you need to go to whatever, 7 days a week, 7 times a day, do it. Nobody's stopping you, right? Everybody's there ready to assist you. You've been through it before. You could probably tell me better than I could tell you what the words are and what the steps are and how to do those things. So I know you know it. And I know from looking at you right now that you know that you need it. So it's just a matter of doing it every day. somewhat easier for you right now because you got lots of support helping you, and I'm glad that you do. But there comes a day when, as a man, you simply have to say, I'm not giving in. I'm not going back down that road. I'm not doing it. And I'm going to fill my life with the good things in life, as opposed to just stuffing some chemical in myself to make me feel a little bit better at the moment. Okay? So I'm going to get off my soapbox and just say it's time. There are no more grace periods. There are no more do-overs. You don't get up tomorrow and say, well, okay, yesterday I messed up. If you mess up, I'm just going to throw you in jail for as long as humanly possible, because that's the only way I can keep you from using and keep you from hurting somebody else. So,
Yes, sir.
having said all that, let me find my form. I'm getting really good at losing. I know that this is a first offense under the drugged driving statute, but I'm going to put you on probation for as long as I possibly can, simply because I think that you need that monitoring to make it out on the other side. So I'm going to put you on probation for 2 years. There's a $720 probation oversight fee. Mr. Fortier, any restitution amount that you're aware of?
No, Your Honor, I didn't get any reimbursement requests from the sheriff's office.
All right. There's a mandatory crime victim fee of $75, a justice assessment of $50, court costs of $400, a fine of $200, and a local charge of $15. Let me add all that up for you.
I love it when the judge understands the
Total
system.
of $1,460. You can pay that off over the course of your 2 years of probation.
Understands what's best for somebody.
You may perform community service in lieu of fines and costs at the discretion of the probation office. You must enroll in and successfully complete treatment educational programs. That would be the intensive outpatient program. Follow all recommendations. If they send you to a methadone clinic or anything like that, that's included under the intensive outpatient program. So you're going to go do whatever they tell you to do, even when you get out of the sober living residence there. If they recommend any additional follow-up, you have to follow their recommendations.
Sure.
There is to be no consumption or possession of alcohol or drugs while you're on probation, no entrance into a business where alcohol is served by the glass. That means you may not go into any bar, even if it happens to serve food. You may go into a restaurant that happens to serve alcohol, but you may not go into the bar portion, and you may not possess or consume any alcohol. Do you understand the difference there?
Yes, sir.
So you can go to Olive Garden, but you can't go to
tested
Beefeaters.
at the discretion of the probation department for drugs and alcohol. I'm going to give you 93 days in jail with 93 days held in abeyance. That means that you're not going to jail immediately. But the first time that you screw up, and I don't care what that screw up is. It may just be you forgot to test. You can't forget anything. You've had way too many chances. So I'm not going to go through that whole speech that I gave you previously, but I want to impress on you how serious I am about this. I am just going to put you in jail for as long as I possibly can if you screw up. So I'm hoping against hope that you don't screw up and that you get this right this time, and I don't have to have this conversation with you ever again. But you know what's coming if you do. All right, 93 days held in abeyance. Because you're in long-term treatment, I'm not going to do any work camp. Yeah.
Judge Hesselink's awesome.
I am going to change my mind on that. I'm going to give you 10 days of work camp, but I'm going to give you a longer period of time to accomplish it. How long do you anticipate you're going to be over there in the treatment program, Mr. Behrens?
It's basically just like a sober roommate. So I can, if I wanted to move out, I can move out at any time, which I don't. I basically just rent a room in a sober house.
All right.
So I can go and
you're out and available now?
Yes, sir.
That's not a treatment program so much as
I'm going to
just
give
sober
you
living.
60 days to do the 10 days of work camp. That means that you would work with your probation department to set those up, but that you'd report to the work camp for the Otsego County Jail 10 days within the next 60 days. Do you understand that?
Yes, sir.
And then you need to keep up with all of your other IOP treatment programs. Let me see if there's anything else I want to do. In addition to the IOP, I want you to go to the Alcohol Highway Safety Education class and the Victim Impact Panel. I know that this is not a drinking and driving, but I want you to be aware so that you don't substitute one for the other. So I'm going to give you a little educational stuff to go to about alcohol, understanding that I know it's not the most serious or pressing concern that you have, but I don't want you to get the idea that you can just say, all right, well, if I can't use fentanyl, can't use opioids, but maybe I could have a drink to give me a little off the edge. Can't do that
Yes.
either.
Yes, sir.
All right. Do you have any questions for me, sir, about the sentence?
I don't. I do not. Do I just call the Monday? Do I just call the probation department?
Yes.
Too.
Yeah. Today's a busy day, so because of the holidays, so why don't we wait till Monday? You'll call the probation department. Let me give you their number. Do you have something to write with?
Yeah.
I'm going to turn off the mic for this while he gets the number. This is Judge Kevin Hasselink. See that up there on the top of the screen? Otsego County District Court.
Aaron's, I did a little bit of chewing you out today. Let me say I am
He's gone.
Hopeful
He's gone.
that this time is the charm. Let's get it done. All right. Good luck to you, sir.
There you go. Great judge. Love the book collection behind him. He bought the entire Encyclopedia Britannica set and has it all on display. 3 years of editions. I like seeing drug court interact with criminal court in this manner, where a judge understands the
All right,
addiction.
we're going to take a mid-morning break. We'll be back in about 5 minutes.
Sounds good. All right. It's afternoon. It's time for lunch. It's time for lunch. Let's see. I hope Stephen does well. I do as well. It sounds like he wants to do better for himself. That he's basically done well for a while and then relapsed, but he understands and he wants to do better. So hopefully with the encouragement of the judge and the programs and the people around him, he can do that. Any update with Pants on the Ground, man? No, I never got that one. I never found it again. Like it either didn't come back or it didn't stream it or something. I don't know. But all right. Let's do this. Let's do a portal. All set up. It's 12 right now. We're going to do 1:30. I've got to run an errand, so 1:30. It gives you a little over an hour for lunch, hour and 15. So get your lunch in. We'll be back this afternoon for more fun. Come on. Did that work? Edit. There it is. Save. Dismiss. All right. All done. All done. It's time for lunch. I got a little bit of scrambled eggs for breakfast, but it was like a bite. It was a bite size. I'm hungry. Not hangry. I'm just a little hungry. Mom bought the encyclopedia set when I was a child. I loved going through all the books. My mom had there was like I don't know what it was. It was like an 1890s book. It was like the doctor's reference, like all the medical knowledge contained in the world in one book, at least in the modern world. And it gave all sorts of bad advice. They were prescribing leeches for just about everything and arsenic for things. It's the most amazing book. It's the most amazing. Please don't study it if you want to be a doctor, though. I think she still has it down in the basement. Just a cool, big reference book of bad medical advice that doctors were doing at the time. All right, tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe. We go live again this afternoon about 1:30. Have a great lunch. Grab some food. We'll be back with more. Guys, be good. See ya. Didn't realize I was off the screen for that. Now we'll see you. Bye.
When are we gonna break for lunch, Judge?